Well, let's now take a look at gun rights advocates celebrating the U.S. Supreme Court's decision Thursday to allow occasional marijuana users to possess firearms. Justices on the High Court ruled unanimously to allow Ali Hamani, a man found with marijuana, cocaine, and a pistol in his home, to keep his Second Amendment rights. Reaction continues to pour in. Joining the states to provide more reaction to this landmark ruling and to unpack what it means for gun owners across the country is Washington gun law host William Kirk. Bill, thanks for taking time with us. Always good to see you. And I want to get your thoughts on this. Did it go the way you thought it was going to go?
Well, first of all, thanks for having me, Greg. Always a pleasure to see you. Last time we were doing this, we were freezing outside of Gat Guns with a nice bonfire in front of us. So this is more comfortable this time.
No question.
So when this case was first taken by the United States Supreme Court at the request of the United States Department of Justice, there was a lot of things about Mr. Hamani's background, not relevant to the case itself, but less than suitable facts, that we figured this would be a bloodbath and 922G3 as applied here would be upheld. Then after hearing oral arguments, many of us were shocked that the tone of questioning appeared to make it seem as though Mr. Hamani might prevail. And just last week on one of my live shows, I had a couple of my co-hosts kind of guess, and they had both said that Hamani would win 6-3. I had actually said he would win 7-2, and it turns out Hamani won 9-0. And I think that's a very interesting thing to see a unanimous court come out on this issue like that. But I think a lot of people might be perhaps over-exaggerating the impact of this case. I think this case has a limited application, and predominantly, I think the group that benefits the most from it are people in states that are allowed to use cannabis for medicinal purposes.
So, of course, they did have kind of narrow, parameters that they spelled out in that ruling, and saying, hey, this doesn't, say that Congress can't determine whether or not specific drugs might cause people to be considered a harm to themselves or others, and a variety of other kind of narrow implications here. But you're essentially saying that, at least as you are an attorney, how you interpret this isn't across the scale, across the board. People can go to the cannabis store and then go to the gun store.
Yeah, no FFL is going to sell you if you're under the influence of any substance, including cannabis. What it does say, and it's a very limited application. There will be people out there who will try to spin this like, oh, it means all the meth heads and all the people strung out on heroin can go buy guns. And it does not say that at all. This was an as-applied challenge, which means that it is limited to the operative facts in the Hamani case, which was that Mr. Hamani, the facts in operation on this case, possessed both a handgun and marijuana and admitted to occasional marijuana use. And what the Supreme Court has said is in those limited circumstances, without anything else, the government doesn't get to categorically ban those individuals.
Bill, there's been a lot of reaction pouring out. Of course, the Second Amendment Foundation, which filed an amicus brief in this case, the executive director, Adam Kraut, he said founding era laws addressed the dangers of intoxication through temporary restrictions, but not the complete ban on firearm possession for the remainder of the person's life. He said, we're thrilled the Supreme Court agrees with us and struck down Mr. Hamani's unconstitutional conviction. Talk a bit about what the Supreme Court ultimately said on that issue of, I think the quote from Justice Gorsuch was something like, we can't allow the government to swallow the Second Amendment right for entire swaths of people.
Mr. Kraut is dead on here. And at the end of the day, there was great debate amongst Second Amendment groups as they were preparing to write their amicus briefs, like, why do we want to help the dopers? Why do we want to help the pot smokers? Because sometimes the pro-marijuana advocates and the pro-2A advocates don't necessarily mix in the same crowd. But ultimately, if the limits of what government can do as it relates to our inalienable right of self-preservation is limited by history, then we have to have all gun laws that are going to be consistent with what we have historically allowed going all the way back to the founding. And the history when it comes to the use of any intoxicants, and by the way, intoxication was not foreign to those who founded this country. In fact, it was a very normal activity, even more so than it is in modern time. And the historical way of dealing with, as they used to call them, drunkards, but anyone under the influence, is that you are not to be in possession of a firearm while you are actually under the influence of those substances. And almost every state, your state and my state, both have laws that say it is against the law to be in possession of a firearm where you are actually under the influence of any substance, legal or otherwise. That's the historical limitations of it. That is a very appropriate way. And those laws, if challenged, your law and my law in our states, they would be upheld because that is absolutely consistent with the historical tradition. But to say that a person, because they got intoxicated on Friday and Saturday night, is precluded from possessing a firearm 7 days a week, 365 days a year, there's no historical tradition for doing that. And the Supreme Court got this ruling right. And to let you know how clearly delineated those lines are from a historical standpoint, all 9 justices agreed with it.
It's pretty remarkable. Here's from the other side, the gun control advocates, Chris Brown, the president of Brady. They said, although the court said that the particular law at issue in this case cannot be upheld specifically as to the person challenging it, it reaffirmed the ability of legislatures to restrict firearm access by certain categories of people. Your thoughts on that statement?
Not an inaccurate statement either. The problem we have with that is, where does that limitation lie on the state legislators? And let me give you an example. There was a big thing out here in Washington that our state Supreme Court had upheld a law that allows disarmament when a person has received 2 DUI-like convictions within a 7-year period of time. Got some national attention for a couple of days. And what the state Supreme Court in Washington had said is hey, listen, the legislature can basically label any group it wants as dangerous, and then we can disarm them. Well, if there is no parameters there, then where does it stop, especially in states that are, much more interested in disarming their citizenship? So, I admit that DUI and impaired driving as a whole is an amazingly dangerous activity. But the real test is are you a danger to yourself or others when you have access to a firearm? That is actually the test here. So we got to be careful about what we're going to allow state legislatures to do as far as labeling certain groups to encapsulate them into the disarmament crowd.
Bill, we've got at least one more case, I think, involving the Second Amendment that the Supreme Court has yet to release an order, or rather an opinion on, and that deals with sensitive places. So we could see that before the term is out, and maybe we connect again to talk more about the issue of sensitive places and whether or not people can carry firearms per the Second Amendment in those areas. But I wanted to just end here with you talking about the upcoming Monday orders list. This is the last one on the calendar for the year. And there's still a lot of different, very controversial lawsuits that are pending in the U.S. Supreme Court. What's going to happen if they don't decide to take, say, the Veramontes case, or they don't decide to take, the slew of other Second Amendment related cases that there are?
If they don't take it on Monday, and tune in live to WGLAM and we can watch it all together live. But if they don't take it on Monday, there's only one of two things that's happened. Either one, they have rejected it, in which case it will be complete dismay in the Second Amendment community, and for good reason, because this is kind of the second year in a row we've been on this little journey here. Last year was 2 cases, Snope in the Ocean State case. This year it's 5 cases, including Duncan v. Bonta, the most deserving case of all of them. Or we could potentially see, Greg, we could see a holdover where they would actually hold them over until the first conference, which is actually the last Thursday of September of this year. And in that situation, if that occurs, they are clearly waiting for a ruling that all of us are expecting out of the Third Circuit in New Jersey, a case called Cheeseman v. Platkin, which is a challenge to their assault weapon ban, which many legal prognosticators, for whatever that's worth, have suggested that they actually think that New Jersey's going to lose that case, lose their assault weapon ban. And now we have a circuit split. New Jersey will be up on appeal too, and it kind of makes it inevitable for the court. They have to take it.
Well, we're going to be watching all of that closely, as you are as well. William Kirk, host of Washington Gun Law, greatly appreciate you taking the time with us, and we'll connect again soon. Be sure to share your thoughts in the comments below about the most recent ruling we talked about concerning guns and drugs, and what other gun control law challenges are most interesting to you.